so I thought a good way to talk about surrogacy law in Canada would be to walk you through the 3 legal steps in a typical surrogacy journey, which will take us on, like, it's chronological. And that way we'll be able to touch on the important legal points involved in surrogacy law, of course. So the 3 legal steps in a surrogacy journey. This is our overview. This is our roadmap for our conversation tonight. So the 3 legal steps are as follows. The first one is entering into the contracts. So for some people, that will be an OVA donation agreement, and tune in next week when we're talking about OVA donation, and a surrogacy agreement. So at this part of the process, both sides of the agreement have independent legal advice. They're working with their own lawyers. There's a drafting component, a negotiation component, some back and forth between the parties and their lawyers. When a final agreement is arrived at, the parties execute, and then legal clearance is sent off to the clinic, the fertility clinic, letting them know that from a legal perspective, they're safe to do whether it's the retrieval or safe to go through with the embryo transfer. So the first part of a surrogacy journey from a legal perspective is putting the proper contracts in place. The second step is the hospital letter or the clinic letter. The parties are really excited at this point because it means that the surrogate's pregnant and she's about halfway through and they're starting to think about becoming parents. And so the purpose of this letter is to put the hospital on notice. So wherever the surrogate's going to deliver, we like to put them on notice. No hospital or clinic wants to be surprised when it comes time to the birth. They want to know who's who and what's what and who the parties are. So that's step number 2, and we'll talk about that in more detail later. And then the third step, the third legal step in a surrogacy journey is, of course, the legal parentage. This is the transfer of legal parentage from the surrogate to the intended parents or parent if it's a single person. So there's a presumption in law that when a woman gives birth to a child, that she's the legal parent. And so action needs to be taken to rebut that presumption of legal parentage and move it from the surrogate to the intended parents. And so these are the 3 things that we're going to talk about tonight. Any questions?
No questions so far. Well, I will have a ton of them, I'm sure, but I'll wait patiently.
Okay, awesome. So
Thank you.
Step number 1, contracts. When I first put together this slideshow, I had a picture of people shaking hands, but I changed it to this because I'm not sure we're going to shake hands anymore after this whole pandemic thing. So step number 1, contracts. So why enter into a surrogacy agreement? Why is this an important step? So there's a whole bunch of important reasons why the party should go to the trouble, the expense of entering into a surrogacy agreement. I've listed a few of them here. So it provides the court with the preconception intentions of the party. So parentage is based on a number of things, genetics, and intention is an important part of parentage. So by entering into a surrogacy agreement, it shows the court who the parties intended at the outset to be the parents of the child. Another reason to enter into a surrogacy agreement is because it allows, well, it forces really the parties to turn their minds to the difficult questions, right? Invasive testing, will the surrogate be required or asked to undergo amniocentesis? What happens if the parties learn that there's a genetic or congenital abnormality with the fetus? Is a termination of the pregnancy an option for these parties? And similarly, a selective reduction. If the surrogate is carrying a multiple pregnancy and they learn that there's an issue with one of the fetuses, what are the parties prepared to do? And so by turning their minds to the difficult questions early, The discussion is not new if the issue arises at a later date. The surrogacy agreement allows for a mutual understanding of the parties' rights and obligations on both sides. So not just the surrogate's obligations, but the intended parent's obligations and the surrogate's rights, and of course the intended parent's rights. The surrogacy agreement also protects against duress or undue influence. You know, I think a lot of people have misconceptions about the relationship between surrogates and intended parents, and whether there's an imbalance of power, who has the power. You know, there's every surrogacy relationship, every arrangement between a set of intended parents or an intended parent and the surrogate is different. It's unique. It has its own dynamics. And so by entering into a surrogacy agreement and having independent legal advice, it can protect against undue influence or duress. I've worked on a few surrogacy agreements over the years where an employee, the surrogate, the employee, was carrying a child for her employer boss. And so those kind of, or they came to us with that arrangement. And so that situation needs to be carefully examined and fleshed out, and are there power imbalances and all that kind of stuff. So it's an important part of the surrogacy arrangement. And then lastly, it ensures compliance with the Assisted Human Reproduction Act, that very important piece of legislation, which I'm going to get into a bit more detail now under this first step. Okay, so under step number 1, we're going to talk about the Assisted Human Reproduction Act, because it's the time that we really turn our mind to it and what it means and what are the obligations under the Act. So, a few important points about the Assisted Human Reproduction Act. So it's federal legislation, which means it applies equally across Canada. So regardless of where your surrogate lives and where the birth is going to happen, the parties are required to abide by the Assisted Human Reproduction Act. It was enacted in 2004, so we've been working with this legislation for about 16 years now. The government has recently come up with regulations under the Assisted Human Reproduction Act. We're going to talk about those in more detail. They come into force in June 2020, okay? The purpose of for our purposes in this discussion, the purpose of the Assisted Human Reproduction Act is to prohibit commercial surrogacy, but to permit altruistic surrogacy. Altruistic, of course, meaning that there's no compensation, there's no payment. So on that point, you can't compensate your surrogate, but you can reimburse her for an expenditure incurred by her in relation to her surrogacy. And then lastly, the onus is on the intended parents to comply with the Assisted Human Reproduction Act, as opposed to the onus being on the surrogate. So an important point for intended parents.
Can you elaborate on what that means, Michelle?
So the legislation, I'm paraphrasing, I don't have it memorized, but let's say in the paraphrase, it says, no person shall compensate a surrogate. So that person being intended parents. I think it's important for everybody to abide by the Assisted Human Reproduction Act and make sure that they're following the laws and the regulations. But essentially what that means is that if there was a breach, the breach would be on the part of the intended parents and not the surrogate.
Okay, thank you.
Okay, so in terms of the regulations that I mentioned that I covered in the last slide, the regulations again come into effect in June 2020. In order to help the public understand those regulations, Health Canada has published what's called a guidance document. And so the guidance document is pretty thick and it's pretty dense. So I've pulled out some important pieces that are relevant to helping us understand the regulations. Expenditures may be reimbursed, but only in accordance with the regulations. So if you're going to be reimbursing your surrogate, it has to be in accordance and following the specifics under the regulations. There's no obligation to reimburse. This is where the surrogacy agreement comes in and is an important piece, obligating the intended parents to reimburse. Reimbursement must not involve a monetary gain. So that it has to be a financially neutral transaction for the surrogate. There can't be gifts that are disguised as payments, for instance. It has to be neutral. Payment of anticipated expenses or an unaccountable allowance would be considered illegal by Health Canada. And then a receipt for the eligible expense must be provided to the reimburser, which is the intended parents, as a condition of the reimbursement, except where there's an exemption provided by the regulations. So an example of an exemption would be mileage. It's hard to have a it's hard to have a receipt rather for mileage. So for mileage, there's a log, you started at this place, you went to that point, how many kilometers was it, etc. Everything else requires an actual receipt.
Sorry,
Petra, say that?
Is mileage the only, or like the most common exemption?
Yeah, mileage is the one that we see most often that doesn't have a formal receipt.
Okay.
There are other reimbursements that may not have a formal receipt. For instance, you know, how childcare or housekeeping. A receipt would need to be produced, but it wouldn't be a formal one with the till, you know, through a cash register, of course.
Right. It could be like a written receipt. That's
exactly. Yeah, exactly. So the reimbursement regulations, a few more important points about them on this slide. So the minister can ask for records or additional information related to the reimbursement. So if you get a notice, there's a requirement to produce records. You have to keep your records for up to 6 years. That's, again, onus on the intended parents to keep their records. You must provide the minister with any record or information related to the reimbursement by the date provided in the notice. I personally don't know any clients who have who Health Canada has ever reached out to about this. You know, this will start happening, of course, in June when the regulations become in effect. So we'll see what that looks like. It's a criminal offense to breach the regulations. Okay, it's the penalty is a maximum fine of $500,000 or a prison term of up to 10 years, which is pretty severe. There's a movement to remove the criminal component from these regulations and from this law. So there may be an update on that in coming months or year. Again, I've said it, the regulations come into effect in June 2020. The reality is lawyers have already been drafting contracts as if these regulations have been in effect for some time. So when June 2020 comes around and we're required to abide by the regulations, I don't think we're going to see any noticeable difference. We're already acting as if the regulations are law and making sure that all expenditures are legit and related to the surrogacy, etc. There's no grandfathering. So if you've entered into your surrogacy agreement now and you think that you're going to be able to avoid the regulations because your surrogacy agreement was entered into before they became law, that's wrong. From the moment the regulations become law, everybody's required to abide by them. So an important question to ask yourself with each expense. This is a really simple test that I encourage my clients to ask themselves. Is the expense related to the pregnancy? Yes, if it is, yes, it's likely eligible for reimbursement. If it's not related to the pregnancy, then it's not eligible for reimbursement. Further, if I were not pregnant, would I have this expense? So if the answer is yes, you would have this expense even if you weren't pregnant. It's not reimbursable. It's likely not reimbursable. For instance, your rent or your mortgage or your child's daycare. You had this expense prior to the surrogacy, and so it's not it's not reimbursable by your intended parents. If the answer is no, I wouldn't have this expense, but for the pregnancy, then yes, it's very likely eligible for reimbursement. That's our starting point. So from the surrogate's perspective, there are a list of reimbursements, expenditures that can be reimbursed to her. And so I've set them out here. I've pulled them out of the regulations, and I just thought we'd go through them because it's a pretty extensive list, to be honest with you. I think it's got everything in it that will allow surrogates to have a safe, healthy pregnancy and not be out of pocket. So travel costs relate, of course, everything I mention here has to be related to the surrogacy. So travel related to the surrogacy, dependent care related to the surrogacy, whether it's your children or your pets, counseling, legal services, so the independent legal advice the surrogate receives related to her surrogacy agreement, the cost of getting a written recommendation for certain products or services, the cost of a midwife or a doula, groceries, maternity clothes, telecommunications. This is the cost of your internet, if it's required to communicate with your intended parents, or long distance charges if you need to communicate with your intended parents in a way is going to incur charges, exercise classes for a fit pregnancy, expenses related to the delivery, life insurance, the cost of obtaining medical records, mileage to get to and from medical appointments or other obligations under the surrogacy agreement at the CRA rate, which in 2020 is 59 cents a kilometer, net lost wages, and then products and services. So I've highlighted products and services because I think it's a really important one. And I'm going to dive into a little bit more detail about it. So products and services, one second, I'm moving your screen because I'm moving the video of you, Petra, because I want to be able to read this and then I'll put it back. So products and services, under the legislation, it says expenditures for obtaining products or services that are provided or recommended in writing by a person authorized under the laws of that province to practice medicine in that province. So that might be, well, your obstetrician, your midwife, your fertility doctor. All of those people are authorized to practice law and can either provide the service or recommend the service, okay? Some of the important products or services are dental care, acupuncture, physiotherapy, massage therapy, reflexology, chiropractic care, yoga, fitness memberships, and other products, okay? Support pillows, pregnancy hose, those sorts of things. I like this subcategory of reimbursable expenses because it's what will help the surrogate get to a healthy pregnancy, a safe pregnancy, and have the things that she needs. The objective is a full-term baby, and many of these things will help the surrogate get there. So under the regulations, in order to have a product or service, the expenditure of a product or service is reimbursed to the surrogate, she's going to need to fill out a form. It's going to need to be recommended. And so I just created this form. We're not attaching these to surrogacy agreements quite yet because we don't need to. But when we do, I'm sure it'll look something like this. So it's a schedule to the surrogacy agreement. We've got the products that have been recommended, the services that can be recommended. This form can be submitted to the transfer physician at the time of transfer or the attending physician at obstetrical appointments or the midwife. They'll recommend a number of products and services, print their name, sign it, and date it. And with that, with this piece of paper, it permits the surrogate to go out and incur that expense and then have it reimbursed to her.
Okay, so basically, whatever the doctor feels would be appropriate throughout the whole pregnancy is checked off, signed, and then that is applicable throughout the whole journey.
Right.
Okay.
That's my interpretation of it. I don't think you're going to need to have it recommended every single time. If you're doing a series of chiropractic visits or massage therapy, I think it would be a tremendous burden on the surrogate to go have the written recommendation every single time. So my interpretation is that this recommendation is for the course of the treatment, whatever it happens to be. Okay, so we're going to move off the Assisted Human Reproduction Act and the regulations that support it, and continue on our step number 1, which is entering into the agreement. So I've pulled out some key sections of a surrogacy agreement. These are important sections that are often negotiated at length or discussed at length between the parties, certainly between the parties and their lawyers, to make sure that they understand their rights and obligations. So the surrogate's prenatal obligations, of course, this is an important one for surrogates and an important one for intended parents. So the surrogacy agreement will set out the prenatal testing expectations, ultrasounds, whether or not there's invasive testing like amniocentesis or chorionic villus sampling. Again, we talked about this a little earlier, but the termination of the pregnancy and selective reduction. The prenatal obligations will also include lifestyle restrictions, like food restrictions for the surrogate, activity restrictions, and travel restrictions. And we'll get into more detail a little later why the travel restrictions are important. But often a surrogacy agreement will say that the surrogate can't leave her province after 24 weeks of the pregnancy, for instance. The objective is for the surrogate to deliver in her province of residence. The prenatal obligation section of the surrogacy agreement will also include lifestyle obligations, so positive obligations on the surrogate, not just prohibitions. So vitamins, for instance, proper diet, exercise, obstetrical visits, that sort of thing. So that's all really clearly set out in the agreement. Of course, as we mentioned, under the Assisted Human Reproduction Act, the surrogacy agreement will cover the reimbursement of expenses. This is the intended parent's obligation now to cover those expenses. The agreement will often include a total amount of a reimbursement. It's often rather on a monthly basis. There's a particular amount. The surrogate has discretion to incur costs related to the surrogacy up to a certain amount per month. Then there's often some items that might be in addition to that monthly amount, things that are if and when scenarios that if they arise, they might increase the surrogate's costs, and so it may not be fair or practicable for those expenses to be reimbursed inside the monthly amount that has been agreed to between the parties. So for instance, if there's a multiple pregnancy, surrogate may need some additional support. If there's a bed rest, if she's ordered by her doctor to be on bed rest or her midwife during the pregnancy, there would be a requirement to reimburse additional childcare or household help. If she's employed outside of the house, there's a requirement, and there's necessities around reimbursing her lost income related to or incurred as a result of the bed rest. And then if she has a C-section, there may be additional expenses after the birth so that she can recover properly without straining herself. So that's covered in quite a bit of detail in the agreement. Parental rights. So, you know, everyone, I think when they think about surrogacy before they're in it, they think that this is probably the most important section of the agreement, making sure that the intended parents have parental rights, and it certainly is. I mean, it's the crux of the agreement. It's everybody's objective for the surrogate not to be the legal parent of the child and for the intended parents to be the legal parent. So, of course, it's covered in detail. The intended parents typically take custody of the child from the moment of birth if they're there, and they most often are. Intended parents will make medical decisions from the moment of birth. Of course, it sets out that the surrogate doesn't have any parental rights to the child, custody rights, access rights, rights to information, which is a technical term, which often includes things like medical records or report cards. And then of course it'll cover the fact that the surrogate will cooperate and assist with whatever is required for the intended parents to become the legal parents. And that there's often a wide range of what those requirements might be, depending on where the intended parents are from. Are they an international couple? Are they a domestic couple? So surrogates often go out of their way after the birth to make sure that intended parents become the legal parents and all the requirements are fulfilled. Another important section is confidentiality. And this is a section that is often negotiated in a lot of detail. I mean, some people are very public, some people are very private. Sometimes we have a private surrogate with public intended parents or vice versa. So the confidentiality section is an important one to make sure that there's been a meeting of the minds on. We never want a situation where there's been a public announcement that one of the parties wasn't ready for or expecting. So typically, yes.
I was going to say, I think that's something that people probably would never think was in there, would be in the agreement. Definitely important, especially for pregnancy announcements.
Yeah, gender reveals.
Yeah, you know, if the parents maybe haven't told people yet that they're even using a surrogate at all. So definitely a good one to be aware of.
Absolutely. I mean, imagine being tagged on Facebook with an announcement that you weren't expecting. So,
oh yeah.
Of course, important implications for social media, Facebook, Twitter, etc., Instagram. I always tell surrogates, as long as it's not contrary to the agreement, that they can share their journey on social media. They can share that they themselves are a surrogate, that they are pregnant with a surrogacy baby, as long as they don't reveal their intended parent's identity or any information that would lead to someone being able to identify the intended parents.
Yeah, so no names, no
names,
tagging.
City, specifics, and any specific information that might lead to their identification.
I think that's good to call out because, I think it's really important for some surrogates to share their journey, especially with their close friends and family. And, they can still do that while being discreet and while maintaining confidentiality.
Right. I mean, they could have initials for their intended parents. That I don't think that identifies intended parents. And, when they're talking about them, use a code word or. I agree. I think it's really important. I mean, it's such a beautiful thing and it's something to be celebrated and people want to celebrate it. But there's a lot of intended parents and a lot of surrogates who are private. I mean, I've had lots of private surrogacy surrogate clients over the years who have said, I just don't want this shared publicly. I'm doing it for them. I'm not doing it for anyone else to know. But also intended parents. I mean, when they've been through a long road often by the time they've arrived at surrogacy, and they want to tell people when they're ready. Yeah. So assumption of risk. This is an important one, I think, for surrogates. And I always go into a lot of detail about this clause in a surrogacy agreement. So the assumption of risk clause covers the fact that the surrogate has given her informed consent. She understands what she's doing from a medical perspective. She's assuming the risk of the transfer, the pregnancy, and the birth. And as we all know, there's a risk. There's a risk to these events and procedures. And so the surrogate's assuming that risk, and it's a big deal. When you peel that back, what that really means from a practical perspective is that if there's a negative outcome for the surrogate, whatever it happens to be, big or small, she's assumed that risk and will not have recourse as against her intended parents. There's no causal connection between entering into the agreement and that negative outcome. And so intended parents can't be held liable. And that's important for intended parents, of course, that they're not liable for something they had no control over. So important for the parties to have thought about this. That doesn't mean that the surrogate may not, the surrogate may well have recourse against medical staff, et cetera, if there was a breach in the standard of medical care. So this section doesn't prevent that, but it just means that the intended parents aren't liable. And then of course, 40 pages, single spaced, there's a whole bunch of other important things in the agreement. I mean, this is not a short document. So how many embryos are being transferred at once? It used to regularly be 2. Now it's almost invariably 1 embryo, trying to avoid a multiple pregnancy. How many transfers will the surrogate agree to undergo? Often the contract sets out that it'll be 3 or maybe 4 transfers, but then there's a way to automatically extend it to cover another transfer if the parties want to have another go. Over what period of time? Is it all of the transfers taking place within 8 months, 12 months, 18 months, that sort of thing? What happens if your intended parents separate? Life insurance clause for the surrogates is an important thing to turn their minds to. Psychological counseling for the surrogate, her spouse, her children, if they feel the need to speak to a counselor about surrogacy related matters or the implications or the impact on their family. And then there's abstinence. There's another clause is abstinence for the surrogate, the requirement to abstain. We're hoping that the surrogate, we're planning that the surrogate won't become pregnant with her own genetic child in that period of time where it's important that she is about to receive a transfer. So those are really the key sections of the surrogacy agreement. Of course, there's more to it, but I wanted to pull out some of the things that are negotiated in detail.
So you mentioned it's about 40 pages long. How long typically does it take for you to go over this with intending parents or with surrogates and get through it all?
Yeah, I mean, I plan for at least an hour in every call. This morning I had one that was a couple of hours long.
Yeah.
And part of the call is getting to know the parties and understanding their circumstances so you can put the whole picture together and make sure that the agreement really does protect them and that they've thought about other things that may not be obvious at first. And so the independent legal advice conversation is always really enjoyable because you get to know someone on a bit of a more personal level, and then of course going into a lot of detail about all this stuff. So I always plan for at least an hour, as I say, sometimes 2.
I always thought it would take longer than that.
Oh yeah, I mean, but that's sort of an initial call. And then there's follow-up, there's multiple, I mean, it's not just one, there's many calls during the negotiation when the other party might want to change. We'll talk about the implications of that change, whether or not something they're prepared to agree to. And so there's tons of back and forth, but in terms of the big long first call, it's at least an hour, yeah.
And are you going into your next section?
Yeah.
Okay, I have one last question about the agreement.
Sure.
You mentioned, we went over a lot of the surrogate obligations, but what are some more of the parental obligations in the contract?
So the obligations on the intended parents outside of the obligation to reimburse.
Mm-hmm.
So, I mean, it's filled with parental obligations, like the obligation to take custody of your child. Okay. Right? The obligation.
More of the obvious ones, I guess.
That's like really obvious, but critical, right?
Mm-hmm.
Surrogates often say to me, I don't want to be, I've had my family, I'm not planning to have another child, I don't want to be stuck. So really obvious one. But what else? If there are international clients, international intended parents arriving here well in advance of the birth to make sure that they're here, that they can be available if their surrogate goes into labor early. Of course, the confidentiality is a obligation on the intended parents. Let me think, what else? Open communication on both sides of the agreement. That's it. Yeah, I mean, those are the really important ones in terms of obligations on the intended parents.
Okay.
Of course, and of course to make sure that the surrogate's not out of pocket. We've covered that in detail.
Right. Yep.
Yeah.
Okay. Great. Thank you.
Okay. Oops, I went too fast over my slide. I don't know how to go back, so I'm going to just leave it. So step number 2, the hospital letter. So this is the hospital letter W5. I mean, this is a short step. It's it doesn't take long to accomplish, but it's an important one for the party. So the who, where, what, why, when. So the lawyer for the intended parents is often the one who drafts and sends off the letter to the hospital. Why do they send this letter? The letter ensures that the intended parents are recognized as the custodial parents and the medical decision makers for the child. That's really the most important part that we're covering. Also, the fact that they can attend the birth of their child, that the hospital or the clinic will release the child into the intended parent's custody when the child's being discharged. That sort of thing is covered. When is the letter sent? It's sent at about 20 to 24 weeks gestation. I really like having the letter on file with the hospital or the clinic by 24 weeks. I can sleep at night because then I know that if the surrogate happens to go into labor early, medical decisions will certainly need to be made. And I like knowing that we've done our part, we've informed everybody, and they know who to look to make medical decisions. So the letter generally extracts the most important parts of the surrogacy agreement, and really we drop it into a letter. It also can cover some things that aren't already in the surrogacy agreement, like insurance information for international intended parents. We talk about who the guardian for the child is in the event that the guardian would need to be contacted. And where is the letter sent? So the letter sent to the obstetrician, the midwife, the social worker, maybe the nurse manager on the mother-baby unit at the hospital or clinic where the surrogate's going to deliver. So typically the parties they see the letter, they've signed a schedule at the back of the letter to say they agree, they've seen it, they approve it. And so everyone's on board and knows that the letter's on file at the relevant place, at the birthplace. Okay, step number 3.
A short step.
Yes, it was a short step. It's just a quick little letter, but it's an important middle step, and everyone's always really excited when we get there.
Yeah.
Step 3, this is the legal parentage. So legal parentage is a provincial matter. Unlike the Assisted Human Reproduction Act, which is federal, and so applies equally and in the same way all across the country, legal parentage is different. Every province across Canada has enacted parentage legislation, which defines who is a parent, who is not a parent, how you become a parent, how parentage is transferred. And so it's important to look at that jurisdiction and understand that the laws differ right across the country, okay? So a few important points about that, about the fact that legal parentage differs from province to province. It's important to examine the facts of each case to see if that combination of surrogates and intended parents can achieve the legal result they want to achieve in that province. And so some of the things that we're looking at is the genetic connection between the intended parents and their child. Are there donor gametes, donor eggs, donor sperm, or donor embryos altogether? And then another one is the marital status of the surrogate. This can become important in some of the provinces. And so we have to turn our minds to it. We need to know, is the surrogate married? Is she separated but still married? I mean, it's important to dig down on these issues and make sure you're working with the right permutation and combination of elements to achieve the right legal result. So for instance, just a couple of points to show how important it is that we think about this. Only in Ontario and British Columbia, so the only 2 provinces in Canada, where you're permitted to build your family through third-party reproduction with the use of a surrogate without the need to have a genetic connection to your child. So in Ontario and BC, you can have donor gametes or have an embryo donated to you and still get both names on the birth certificate. In every other province across the country, at least one parent needs to have a genetic relationship with the child. And then for instance, in Manitoba, now I know my lawyer friends in Manitoba are working hard to change this. But for instance, currently in Manitoba, if the intended parents are a couple, the surrogate needs to be single in order for the right legal result to be achieved, where both of their names end up on the birth certificate. And so again, just really important to turn your minds, speak to a fertility lawyer in the province where the birth is going to happen to confirm that the result is achievable.
And I'm glad that you mentioned that you have friends working on this, because
Yeah.
it's good to note that it's ever changing, especially with the provincial processes. They might change in a couple of months, or if there's a new judge or something,
That's
can totally throw it up.
That's exactly it, Petra. And frankly, that's exactly what happened in Manitoba.
Yeah.
So it's really important to constantly be checking in and speak to the people who know and who have inside information in the province in terms of where things stand.
Awesome. Thank you.
Okay. Legal parentage in Ontario. There are two options. In Ontario, you can become the legal parents of your child born through surrogacy by way of a statutory declaration. I call this the administrative process, or through a declaration of parentage, which I call the judicial process. So two options in Ontario that are used in different scenarios as follows. So a statutory declaration. This process only became available in January of 2017, so it's only a few years old at this point. In order to take advantage, and I say take advantage because it's a simpler, more streamlined step. So in order to take advantage of the statutory declaration process, there are three criteria. And so the criteria are that the parties have independent legal advice on their surrogacy agreement, that the surrogacy agreement is, one, that there's a surrogacy agreement. Let's go through this step by step. One, that there's a surrogacy agreement. Two, that they've had independent legal advice on the surrogacy agreement. And three, that the agreement is signed and fully executed prior to the date of the embryo transfer. So you have to be organized. This is not something, the surrogacy agreement has to be signed and sealed and delivered, basically, before the embryo transfer in order to take advantage of this post-birth legal process. Okay. So in this process, the parties swear statutory declarations, which are fairly straightforward documents. The surrogate has to wait 7 days post-birth in order to be able to swear that document. So it's sworn with a notary public or a lawyer, commissioner of oaths, but she does have to wait 7 days for that.
So just to clarify, so the statutory declaration is done 7 days post-birth.
Yep.
Do you do any preparation before the birth to get this ready?
No, it's not. It's really not necessary. From a drafting perspective, it's pre-drafted. It's a standard form document. What I do is, in these times of COVID-19, in the last month or so, I have been sending the documents to clients in advance, and so they've got them, and limiting their requirement to go out and into the public, and we've been notarizing virtually and that sort of thing. So typically no advance work is required, but in these times a little bit of advanced planning is helpful. And then it's simply a birth registration package that's provided to the Registrar General for the province of Ontario. Typically the lawyer for the intended parents liaises with the registrar, make sure all the requirements are filled in order to be able to transfer that legal parentage from the surrogate to the intended parents. So with this process, the document that you're going to end up with in the end is the birth certificate. You'll have a birth certificate which does not have a surrogate's name on it in Ontario. You'll have either the single parent's name, whether it's a mother or a father, or the couple's name, whether it's two women, two men, whomever. So you'll simply, the result of this process is a birth certificate. Unlike the Declaration of Parentage. This is a judicial process, as I say, because you end up with a court order. So not only do you have birth certificates at the end of this process, you also have a court order. So it's a post-birth court application. And in Canada, unlike our friends to the south, we don't have pre-birth orders. It's not a thing here. All of this legal work to transfer legal parentage can only be undertaken when you have a child who's already been born. So it's a post-birth court application made at the Ontario Superior Court of Justice level. And we're asking the court, in the court order, for some important pieces of relief. We're asking the court to declare that the intended parents are the child's only legal parents. In Ontario, a child can have up to 4 legal parents on their birth certificate. It's an incredible thing. Beautiful thing that recognizes that families in Ontario are made in a whole bunch of different ways. And so the court order makes a declaration, so it's clear to everybody that only the intended parents are the legal parents of the child. It declares, it actually involves a declaration of non-parentage, if I'm being technical. So a declaration that the surrogate and her spouse, if she's married, are not the legal parents of the child. That's also on the face of the court order. Permission to register the child in the names of the intended parents, as opposed to the name of the surrogate. So in Ontario, we have a 2-step birth registration process. We have the Form 1, Notice of Live Birth, which is filled out at the hospital or the clinic. And it's factual. It's this person gave birth to this child at this location on this date, this gender, this weight, okay? And so the Notice of Live Birth Form 1 is then compared with the Statement of Live Birth Form 2, which parents fill out with their information. And so when the Notice of Live Birth and the Statement of Live Birth don't match, that's where you need to take a positive step and rectify the situation. And so the Declaration of Parentage is the court ordering that the registrar register the birth in a way that is different than what the Notice of Live Birth Form 1 says.
Okay.
That's why it's important to take this step after the birth, is because we've got those 2 birth registration steps and they don't match. And so we're bridging the gap between the Form 1 and the Form 2. And then sometimes we ask for the court file to be sealed as well in that court order.
So with this statutory declaration, that also goes through both forms.
Yeah,
correct?
exactly. So it's the same. You need the statutory declaration for the same reason that you need the Declaration of Parentage, is that the Form 1 won't match the Form 2. And for the statutory declaration, it's really, who takes advantage of it is mostly my domestic clients. So Canadian residents, Canadian citizens who don't need a court order. And so that's who's using the statutory declaration. Moving to my next slide, I talk about who tends to follow the Declaration of Parentage route. So we'll touch on that in one sec. So step 3 continued. We used to need a DNA test as of about, I want to say 2 years ago, if my memory serves me, when we stopped requiring, the court stopped requiring us to produce a DNA report. So in Ontario, under the Declaration of Parentage step, there is not a requirement for a DNA report. What we do now is we submit a letter signed by the medical director or the fertility doctor, which sets out how the embryo was created, when it was transferred to the surrogate. If we make a claim in court documents, if parties are swearing affidavits which say how the embryo was created, the date that the embryo transfer took place, we typically in a litigation or in a court proceeding need to substantiate those facts. And so the letter from the fertility clinic substantiates the claims of how the embryo was created and when the transfer took place.
Wow, I remember those forms when I was a nurse, and we never really, knew, I guess, how important those are. Obviously, we took very great care in them, but That's really cool to see where it goes.
Yeah, it goes before a judge who examines it and makes sure that the dates line up to what the parties are saying, and you better have your facts straight.
Yeah.
So in a declaration of parentage, I have to say judges do look at the surrogacy agreement, okay? Not in a statutory declaration. In the statutory declaration process, the surrogacy agreement, DNA tests or letters from the clinics are not required. It's not part of the process. But when you go before a judge and the judge is going to sign a court order that you're asking them to sign, they want to make sure that they've substantiated that there's veracity behind what's sworn in the documents.
So to clarify, because in this, one of the criteria was that there is a legal agreement. So they don't need the physical agreement, just to the knowledge that there is one.
They're swearing a document with a commissioner of oaths, so it's sworn evidence. It's equivalent to testimony, viva voce evidence that's given in court. They're swearing a document which says they entered into a surrogacy agreement. It says the date that the agreement was signed. They're swearing to the fact that they received independent legal advice, and there was swearing to the fact that the agreement was entered into prior to the conception of the child.
Mm-hmm.
So conception is technically is not when the embryo was created, but when the embryo was transferred to the surrogate. We call that conception.
Okay.
Yeah. So most international intended parents, oh, you can see my mouse. Most international intended parents still want to pursue the declaration of parentage. There's a couple jurisdictions that intended parents go home to internationally where a court order is not required, but most international intended parents do pursue the judicial route or the declaration of parentage route because they want to go home with a court order for citizenship or nationality purposes back home. For international parents, the process typically takes 3 to 4 weeks post-birth, so starting on the date of birth. By the time they get their birth certificates in hand and the passport and they're going home, it's typically 3 to 4 weeks. And then at the end of the process, they'll receive the short form and long form birth certificate. Typically, we send it off by courier. And that is the end of the process. That is the end of the surrogacy journey, and the parenting journey begins.
And I have a question quickly on this step. If it's just the judicial order, the statutory declaration, how long does that usually take typically in Ontario?
Yeah, so you can't sign it until 7 days post-birth.
Mm-hmm.
So my math is usually like this. This is what I explain to clients. The stat dec gets signed typically on the 7th day or 7 days post-birth, at least. Then we have to courier that statutory declaration and packages to the registrar up in Thunder Bay. So there's a day.
Okay.
And then the one part of this process we can't control, and the registrar general is amazing. They really do turn around the birth certificates very, very quickly, particularly when there's a need to, when intended parents need to leave the country quickly, or there's some other reason why the birth certificate is urgent. You know, that birth certificate can come sometimes in a matter of days, sometimes a week. Often the stat dec process, I like to say, takes a maximum of 2 weeks. Now, parents who are having children in the province of Ontario without the assistance of third-party reproduction, their birth certificates take a lot longer. You know, they can take up to 6 to 8 weeks. But
no. Yeah.
But with third-party reproduction, it does go to a bit of a special department. And they do try to get out those birth certificates and attend to it very quickly.
Yeah,
especially they're very responsive up there in Thunder Bay.
Mm-hmm. Odd place for it, but
it's a big office. I once had a client, against my instructions, fly up to Thunder Bay to pick up the birth certificate. Let's just say they were very accommodating. There's no kiosk. There's no place you walk up to get your birth certificate. So
just an office.
Yeah, it's an odd place for it, and especially when parents show up to get them by hand. Okay, so I wanted to, because it's relevant, quickly touch on the impact of COVID-19. I really don't have a ton to say about this, to be honest with you. Contracts already include an obligation on surrogates, and just common sense, and the surrogate's health and her family's health, and it's just common sense, and surrogates care deeply about the child they're carrying, and of course their family. So there's already an obligation to make best efforts to avoid a communicable illness. And so that's obvious. Contracts don't need to be amended because of COVID-19 to cover that. It's already there. There may be a requirement to amend contracts. I mean, I have to extend the term of the agreement if there's been a long delay. You know, if the parties thought they were having a transfer in 1 month, but they've had to wait 6 months to have the transfer because of COVID-19, there may be a requirement to amend the contract to extend the term so they can get in that transfer. But often contracts include a provision that automatically extend it, so this may not be relevant in every case. I hear, and this is not official word, I hear clinics are talking about opening in May. I don't know what you're hearing, Petra.
I've heard the same thing, and as hopeful and optimistic as I would like to be, I'll believe it when it happens.
Yeah, so here's what I do know. So the Canadian Fertility and Andrology Society published yesterday an update, and here's what it said. They drafted, so it was a document drafted by a national subcommittee of medical directors across Canada. All fertility clinics are going to be guided by uniform principles working towards a safe resumption of fertility services now and in all likelihood continuing into the foreseeable future with no end in sight. And that clinics are working together to design safe practices and procedures and protocols prior to opening. And what I like about this is what I'm hearing is that the medical directors and fertility doctors are all working together to have a uniform standard for fertility clinics across the country, so that there's a predictability and obviously safety first. I know clinics only want to open when it's safe, and safety of staff and patients, etc. Mm-hmm. So that's my COVID-19 update or impact. I mean, we all know the impact has been the most noticeable impact so far has been parties having to wait to build their families, which is really difficult.
Mm-hmm. Yeah. How has it affected some of your recent births, if you have any international parents?
Yeah, so it's had a significant impact, of course, with the borders being closed. We've been working with immigration lawyers to help and global affairs to help international clients get the documents they need and permissions they need to enter the country. And so it's a process that we're starting well in advance of the date of birth, and clients are arriving a lot earlier than they originally anticipated because of course there's a requirement to quarantine for the 14 days. So it's had a tremendous impact, not only on domestic intended parents who are either having their babies or waiting to have their fertility treatment, but it's really had a tremendous impact on international parents trying to get here to attend the birth of their child in a timely way. So not easy, but so far I haven't heard of intended parents being prohibited from entering in the country. The process is working. Parents are getting here, they're in quarantining. I've got several sets of intended parent clients now here quarantining or just out of quarantine and waiting for the birth. So it's exciting.
That is exciting. Well, it's, I just wanted to mention while we chat for a little bit, to those of you who are listening, please send in questions. Michelle would be happy to answer them, and maybe we'll just stay on for a few more minutes.
Yeah, for sure.
Yeah, I think that it has been a better experience for Canadian surrogate births compared to some of the American surrogate births, from what I'm hearing.
Is that what you're hearing?
Yeah, well, we've had, at Extraordinary Conceptions, there have been some babies born that their parents have not been able to get in
No.
the United States yet. So either those babies are with a power of attorney. But the most amazing story we've had is that we actually have a former surrogate, who offered to care for another surrogate baby.
Oh, that's incredible.
Yeah, so she's really special. She drove her family to another state to go and pick up the baby. And then they've been caring for the little baby in their home until his parents can come pick him
Oh,
up.
that is beyond. That's
I
incredible.
know.
Wow.
Yeah.
There are
Such an awesome
lots of
story.
good people in this world
Oh gosh,
who will
yeah.
really step up, right?
Yeah.
In these crazy times.
Yeah. Yeah. It's amazing.
When do they expect the parents to get here or to get to
I'm
arrive
not
in the US?
sure. I'm
Okay.
not sure. I think they're in China, so
Okay.
definitely hard for Chinese parents to get into the United States, especially right now.
Yeah. Yeah.
So it might be a little bit.
I did have clients come from China last week.
Oh yeah, good.
Yeah, and got here safely and quarantining and waiting for the birth. So
Good.
we've been able to accommodate and get intended parents in even from China too. So it's
Perfect.
great.
Well, go Canada.
Yeah, exactly.
We have a question from Janice.
Sure.
She says, due to COVID, are contracts still proceeding at normal timeframes, or are you finding that there are delays?
Oh, certainly delays.
Okay.
Delays because, like Janice, delays in the negotiation of the contract? Or I wonder if, well, I'll address both. So certainly delays because fertility clinics have been closed and intended parents and surrogates aren't able to have the fertility treatment they need. So certainly delays in that regard. What I've noticed though, which was unexpected, was that intended parents and surrogates have been wanting to negotiate their contracts in this quiet period. I think people have wanted to take advantage of the time that clinics are closed and get the legal clearance letters in, and then hoping to be first in line when it comes time to reopen the clinics. And I'm not sure how clinics are going to do that. I don't know if they're going to be triaging, or is it first come, first serve, or are they going to assist domestic intended parents before internationals? I really don't know what that's going to look like. But my experience has been parties want to work on the contract, push through the negotiation and execution, and get those contracts completed now. So no, it's been going at a steady pace.
Yeah, I think that's what we've experienced as well. And in fact, it's something we're encouraging too, so that at least you can still keep moving forward in things you can do from home, and using Zoom or Skype or telecommunications to do. And I know that you, Michelle, have helped us to do that faster, maybe at an earlier time than we usually would have, so that at least parents who have already been waiting so long to have their baby aren't held up even longer.
I think it's taking an approach of looking ahead to brighter days and knowing that things will get better and we'll get on the other side of it. And parents and parties are staying hopeful.
Yeah.
And still planning their families.
Yeah, for sure. We noticed a little bit of a slowdown in March, but I think
for sure.
April, everybody kind of got over it and picked back up. So yeah, happy to see that.
Yeah, I was too. And I mean, it means a little bit of risk sometimes for intended parents, because it might mean starting the negotiation or drafting a negotiation process prior to the surrogate completing her screening at the clinic, which the typical order of things is that The surrogate is screened, she passes her medical screening, then the parties start to negotiate the contract because we know from a medical perspective she's cleared to be a surrogate. So I've noticed that intended parents are assuming a little bit more of the risk, again, looking to brighter days, and starting the contracts phase before the surrogate has been screened in some cases. Yeah.
Okay, I think that's all the questions we have.
Hey.
Michelle, you explained everything so thoroughly and, you know, very in a way that I think most will understand. So I really appreciate your time and effort to having this presentation ready for us.
Absolutely, my pleasure. Thank you. I really appreciate you inviting me. It was lovely to talk to you, as always, Petra. You're a delight. So we'll see you next week.
Yes. So next week, Michelle is going to join us again, this time to talk about egg donor agreements in Canada. And we'll go through that process as well. And we've got thank yous coming in on Facebook, Michelle.
Oh, good.
So thank you so much for your evening with us. And we can't wait to see you next week.
Wonderful. Thank you so much, Petra. See you next week.
See you next week.
Bye.
Okay.